advisor. I help entrepreneurs and enterprises to build their digital brand and monetize it. And thanks for the feedback. Well, you have been giving us for the past episodes. I hope that's been value to you and your colleagues. And if you are new watching this right now, welcome to the show where we talk about the legal issues that matters in your life and business. Today's episode, so we want to dig a little bit deeper on alternative dispute resolution. And that's why I have got a very special guest, our principal, Len Watt. Welcome to the show.
G'day, Robin. How are you? It's nice to be here. Thank you. Thank you.
Right,
Very
nice.
Generous opening.
Oh yeah, Thursday afternoon. Why not? 5 o'clock. We gotta obviously spice up and add a value where we can. So
Yep.
I'm conscious with those viewers who are watching this right now. And by the way, guys, if you're watching this, feel free to give us a thumbs up, comment it, share it. And Len have always been so generous and getting so many comments and feedback. So we are on top of it. So if there is any specific questions you want to throw out right now or after the chat, feel free. Now, let's talk about ADR.
Yes.
What is ADR, Len?
So ADR is alternate dispute resolution. It's an alternative way of resolving a dispute between parties that doesn't involve going to court. So it generally allows for the participants to have a say in the outcome of a dispute. It allows for the parties within the structure of the forum that they're in to discuss the issues that have led to the dispute and hopefully come to some form of commercial agreement, generally taking into account all the circumstances that each side will have and not leave the decision to a court or tribunal. So most contracts these days will, that people are entering into will have an ADR clause. And they'll sort of allow the parties to using one of the various ADR methods to go through a process that's cost effective and a little bit more controlled rather than going to court. So ADR in some jurisdictions such as the family court is more often than not a first step before going through a further before getting more into the process.
You bet. Okay, I hope that's been a very clear to. It's a little bit technical, but the whole idea you're talking about is alternative disputes. It's alternative way to before going to court. Yeah.
Well, I suppose if generally you hope that contractual and other types of relationships are resolved to the mutual satisfaction of both parties, but that's not always the case. And a lot of times disputes do arise. So then it sort of comes down to how those disputes are resolved. Obviously, one way is to go and seek the assistance of a court or tribunal.
Yep.
It can be expensive, take a long time, and it's taken out of your hands. So if you walk into a court or into a tribunal, you put your fate in relation to that particular dispute into the hands of the person who's making that decision. And that's a person that is appointed by the courts or the tribunal. It's not someone that you have any say in, who is doing it. So it can be, a rather daunting experience. ADR, on the other hand, allows for, parties to hopefully talk through their issues and look to see how they can resolve. And there are various methods of ADR.
You bet. Now, you just touched on various methods. So what are they? The viewers are some of the feedbacks we're getting. They're curious to know what are the various methods and what does that mean, obviously, in a very simple language, Len, if we can, please.
Okay. So, look, I mean, obviously, without making things too technical, and most of these aren't, to be honest, most of them are fairly straightforward. So first one, negotiation, and it speaks for itself. So, two parties to a dispute can meet in an informal setting with or without legal representation, and they can discuss their issues. Now, if they come to an agreement, then the dispute's resolved, and they can move on. It's a quite fast method of it's cost effective. It's not subject to a published decision as a court matter is, so therefore there's some confidentiality, and hopefully at the end it can preserve the relationship between the parties. So number one, the easy one, negotiation.
Negotiation. That's what we are hearing. Yep, that's great advice, Len. Even as being a legal advisor, highlighting you or you focusing on the negotiation. That's awesome. That's great to hear. And obviously that is one of your points of difference, isn't it?
Yep. So there's a few others. So we'll just go through them in turn. So an expert determination, it's not one that the people, that a lot of people are going to come across. So generally what you have, it's the parties can agree to appoint an independent third party who has expertise in the subject matter, and that party will determine the dispute because they have on the basis of that expertise. So it can be an inexpensive way to answer, say, a discrete technical style or valuation question. It's often used in commercial leases, and particularly in the UK, where it's used for rent reviews within lease agreements. So, shop holders out there and business owners who are leasing premises, they'll be well aware that, there's the annual rent review. If there's a dispute, then, expert determination can be used to resolve what that rent increase is going to be.
That's very good. Now, also on that note, Len, obviously that's very clear that you mentioned about various types of ADR. Is it something that our viewers should be aware of? In what circumstances would that be then?
Well, okay, so one of the ones that I suppose there are other methods, but one of the ones that we need to talk about in relation to what most of our viewers will come across is mediation, which is it allows for a neutral third party to assist in the resolution of a dispute. So generally a mediator is appointed, and that mediator will then review the position of each party, and while they're not there to give legal advice or make decisions, they can assist the parties with some perspective to come to a decision. So, for example, there are a couple of different examples I'll just quickly run through. So, within a building dispute, the domestic building dispute, if it's referred to QCAT or VCAT or NCAT, then there's a compulsory conference, which is a mediation. The compulsory conference is generally chaired by an experienced member of the tribunal who will help the parties hopefully seek resolution to the dispute. Another place where people will encounter a mediation is in the family law area. So it's often used to see if the parties can reach an agreement on property matters or child custody matters before they end up in the full-blown court system. Wills and estates is another area where if there's a family provision claim that we've discussed previously in one of the episodes, that can be determined by the parties in a mediation before it ends up in the court. So the idea is to try and have some say in the settlement of the dispute. It's often said that a good result in mediation is when both parties walk away unhappy, believe it or not. But it means that you've won something, but you've had to give up something, and it settles the dispute, and you can move on.
Oh, you bet. Now, that's a great insight, Len. Thank you so much. Now, just obviously, I'm conscious with the time, but just curious to know, is the outcome of the ADR process binding? What's your thought on that?
In the most often, yes. The parties will in, say, terms of a mediation, which is sort of, I suppose, the area we've focused on, they come to an agreement. That agreement will be documented and the terms put into practice. It can be that people recant on their mediation agreements, and I have been involved recently in a matter where that happened. But the legislation in force around this area allows for you to then go to court and have the agreement, sort of ratified and the terms of the agreement applied to the dispute. So, yes, you would say that in most cases, the outcome of one of these types of negotiations or processes is binding, but never say never. There is always the exception to the rule, but most often and generally you could say that they're binding. Yes.
Thank you so much, Len. I really appreciate it. I hope the viewers really get that very clarity. But if there is any specific questions, any specific situation, they can get in touch. So the best way to get in touch with you and your team is
the number. Well, first of all, we've got the email, which is info@beckerwatt.com.au. Our phone number 1300-legal is another way that we can be reached. And finally, via the website where people can request a consultation, and that's www.beckerwatt.com.au. So
right.
We're very accessible and more than happy to help.
Beautiful. Thank you so much, Len. All the details are right below in the screen as well. If you're watching this right now, 1300-legal. By the way, guys, if you're still watching and if you see this is the value and you want to know a little bit deeper on some other specific issues you are facing in your life and your business, head down to our channel, Talking Legal, where you would see our past episodes. The feedback has been really great, and we're really thankful to all of those viewers and the feedback. And Len and his teams is definitely committed to help and assist them. Now, anything before we close in terms of the ADR at this point, Len?
The ADR is I suppose something that plays or that speaks to me, because I believe in trying to resolve matters before you end up in court. I think that it's important for legal practitioners, or it's my view that our role is to stop people from getting to court. So if we're doing our job properly, or I feel that when we're doing our job properly, we can help people settle the disputes that come along in the daily parts of their life. And the use of an ADR process is often a good way to do that. So I would always recommend to people to talk to their legal advisor and right. see how they can use these alternative methods of resolving the dispute rather than going straight to the courts.
Thank you so much, Len. And as Len mentioned about, just go to beckerwatt.com.au, where you would see 20 minutes, as well as there is a 60 minutes initial consultation, isn't it, Len?
Yes.
So they can book either 20 minutes, 60 minutes, and one of our specialists, Len's team would get through it, and more than happy to assist through. Thank you so much, Len. Once again, it's great to have you, and looking forward to doing more episodes in coming weeks.
Thank you very much. It was
beautiful.
Nice to be
and thanks, guys. If you see the value of this show, feel free to like it, gives a thumbs up, comment it, and share with the wider community. We are all here to add value and support in your life and business. Bye for now.
Thank you. Goodbye.